this year, we do have what I would call a major rule package to go through that came out through the rules process. Rules went into effect September 15th. We did a presentation for Iowa Pork Producers Association, that a webcast or webinar, and it's on the Pork Producer Association website now, where we spent over 2 hours going through this stuff, and used most of that 2 hours, as I recall. Today I'm going to try and squeeze that down into an hour, so in doing that, obviously we're going to have to move right along. Some of the slides you have, this is not the full slide set I did in September. I tried to cut a few out, but also you'll see there are slide numbers on the lower right-hand corner of the slides. I'm going to try and move right through today, and if I skip through a few, I'll try and say I'm moving to slide number 12 or whatever. I realize when you're sitting there with an outline and trying to make a few notes or whatever, when I start skipping through, if it's something you really wanted to see, make a note, and check out the slide, or feel free to catch me. I'll be around Pork Congress for the next 2 days, and I'd be glad to visit with you about any of that. Also, I want to start out with, many of you know, gosh, I was thinking about the history of this the other day. Many of you know, starting in, well, the first major law we had in this area was in 1995, House File 519. Shortly after that, within the next couple of years, the Iowa Pork Producers Association, working with the other farm groups, put out a handbook called the Environmental Regulations Handbook. We did that in, I don't know, it was 96 or so when we got it out in hard copy form, and then again when we updated it following the 1998 legislation, and then following the 2002 legislation, which was the last major set of legislation that we've had. We've had some rules since then. Last year we put it on the Pork Producer Association website. Didn't print it in hard copy. You're welcome to do that, but it's on the website. Well, of course, along comes the September 15 rules changes and some other changes that have happened over the years previous to that. So now I probably should have had it done by September 15th, but I didn't get that done. And Pork Congress was a good reason for me to get it done, working with Jared Hill in my office. We have updated that, and I just have a hard copy here. We'll have at the Pork Producer Association booth and at the Coalition to Support Iowa's Farmers booth. And again, we're not putting it out in hard copy form. It'll be on the Pork Producer Association website. This is just a draft copy that we'll have at the booth for you to take a look at. But it's 2 chapters that we have ready to go: manure management and construction requirements. The manure management chapter is 40, I think 35 some pages, something like that, and the construction requirements chapter is close to 197 or something like that. Now, again, we are able to go into a lot more detail in that handbook, and so my attempt with the slides here today is to just, again, give you an outline, focus on the changes in the DNR rules, and starting next week you can go to the Pork Producer Association website and listen to this presentation, again, if you're so inclined, and number 2, you can take a look at our handbook. And I also would like feedback on that handbook too. If you take a look at it and if there's something that you think you would like to see that's not in there that you think should be, or something that you think we could do better explaining or whatever, let us know. We want that handbook to be a tool you can use to give you the detail. And one thing we try and do in the handbook, ever since we first started doing it, there are note boxes there. And you know, sometimes I refer to, and others, gray areas that nobody can, the rules say this, the law says this, and I may tell you this is the way I interpret the law in DNR, or others may interpret it another way, so it's a gray area. Well, appropriately, we try and set those kind of things out in note boxes, and they're shaded gray. So what I hope what the value of that handbook is, and I can't give you an answer if there is no answer if it's a gray area, but I can at least tell you it's a gray area, and here's what I think. And sometimes I get myself in trouble for doing that, because maybe I say something that turns out is wrong under the law, but I don't think it does you any good sitting in those chairs if I just stand up here and tell you, here's what the rule says. I've got to tell you the gray areas, I've got to tell you what I think about it, what DNR's interpretation may be, and then we go from there. And speaking of that, I do this to him every year. We have Gene Gene Tinker here. Raise your hand, Gene. Gene is with us here today from the Iowa DNR, and I do this to Gene every year. If we get to a spot, I may ask Gene to comment. He keeps coming back every year, so I assume I haven't offended him yet. But it is very helpful. We appreciate Gene coming because I want to give you the best information I can, current rules and some DNR interpretations. And again, those of you who have been here before are well aware. I'll tell you what I think, and if I disagree with DNR, I'll tell you that. But here's what I'll say about this last rule package, and then we'll get into the details. There are some very good things in this rule package. A lot of the good things are things that got taken out, such as the change in the definition of residence. There was a proposal to change that. That's gone. It didn't pass. And what I've tried to do in these slides, you'll see in your handouts, and you'll see when I get to it on the screen, I've underlined the rule changes. And that's what I want to focus on today with the time we have. But sometimes I give you some slides before and after so you have some context to what the rule changes were. First of all, what is a confinement feeding operation and what is an open feedlot operation? I give you the two definitions here. Confinement is an animal feeding operation in which animals are confined to areas which are totally roofed. Now, Gene is also already grinning a little bit back there because he knows where I'm going with this. EPC adopted a rule that's effective September 15 that says animals, the definition of partially roofed animal feeding operation. I'll cut to the chase here. What are we talking about here, folks? Primarily hog hoop barns and cattle deep bedded or cattle hoop barns. That's what we're talking about here. I've never really had this issue on a hog confinement building with liquid manure storage. Gene, I don't think we run into it much there. Here's what we're running into. These cattle barns, confinement barns, deep bedded, that is dry bedded, whatever you want to call it, and some of the hog hoop buildings will have either an area on one side of the barn that's open. Primarily in cattle barns we've seen that, and the question was that a confinement operation or an open feedlot operation, because the law says it has to be totally roofed. Animals have to be in the area that's totally roofed, but maybe the feed bunk, maybe 15 feet on the one end where the feed bunk is outside. Is that an open feedlot or a confinement? Many of those have been permitted in Iowa as an open feedlot, but the rule now says that the unroofed area, right down here, the unroofed area must be at least 10% of the square footage of the inside area. So you got to have at least 10% or more outside for it to be an open feedlot. If it's less than 10%, it's considered a confinement. Now this, right off the bat, here's where I disagree with this rule. I don't think this rule complies with the code as adopted by the legislature, because the legislature said it has to be totally roofed to be a confinement. And if you've got 8% outside, that's not totally roofed. That's my opinion. This rule is in effect, and if you have that situation and are building a new one, you got to be aware of this rule. If you're going to have less than 10% outside, it would be considered a confinement, even though some's outside. Secondly, and here's where I may call on Gene right off the bat, what if you have a cattle barn like that, or a deep bedded a swine hoop barn like that that's already there and was considered an open feedlot when you build it? I'll say what I believe DNR's interpretation is, and we'll see if Gene agrees with me. My understanding is for those requirements you can't change, like separation distance to a neighbor or a construction permit requirement, they aren't going to make you go back and do something you can't do. Okay? But the key there would be is if you were an open feedlot when you built, but now under this rule you'd be a confinement, do you need a manure management plan? And it's my understanding DNR expects you to now get a manure management plan. Is that correct, Gene? And has any time period or... there's nothing in the rule about getting a time period to do that, but I've had this question from several, and I realize I'm spending some time here on something that may not apply to a lot of you, but I know we have some manure management planners here, etc., and work with some swine hoop buildings or some cattle buildings, and I think this is an issue you might run into. Anything to add there, Gene, to what I've talked about? Well, Gene said they have the option of increasing the outside area to get above the 10%. That's correct. Also, you'll see here on the slide, the animals must have unrestricted access between the inside and outside areas. I run into this with dairies quite a bit, where it's a confinement, but like a freestall barn, but they have an outside lot, but they put a gate up, and when the weather's bad, they shut them in. This is where Gina and I have had a few discussions on this one, too. The rule says they must have unrestricted access between inside and outside areas. When it's 10 below and you don't want those cows outside, Gene, and they close the gate, what happens? My understanding of the DNR interpretation is, okay, if you have to close the gate for certain things or certain times, like handling, treating, whatever, fine, but those gates better be open by far the majority of the time. When there isn't a specific reason to have them inside, those gates better be open. Okay. Adjacency, we've talked about that quite a bit in past years. What is one operation or two? And you can see the distance here. Again, what we're talking about, you have two confinement buildings. How far apart do they have to be separate so that you don't have to add them together to get a permit, to get a manure management plan, etc. Here's the new rule. And we have a couple of things to talk about here. What we've run into in some year, you have a common manure storage for two different sites. And this slide 5 here. And the question is, does that make you, for instance, you'll see the bottom one there, anaerobic digesters. We've had a couple operations in the state where there's what I would call a community anaerobic digester, where they take the manure to and run it through a digester. Well, if that's taking in manure from several operations, does that make them all one because it's a common manure storage system? And the answer is no, because this DNR rule says it does not include anaerobic digesters. Here's a much more common situation, and that is you have two completely separate sites. They're far enough away, they're separate, but you have fields in both MMPs. Because you never know, one year you may apply from this site on this field, and one year you'll haul it from the other site. Does that make you one site? This rule clarifies that it does not. Gene, I'm going to put you, boy, I'm really picking on you. How does EPA look at this regarding common manure application areas? Do you know? Gene said as long as you don't get water in or manure in water of the state, they don't care. Here's the big one that we've had trouble, I will say, I'll use the word trouble, or that at least has been an issue for years. And that is the rule that, what is common management? And if you were contract feeding for one owner of pigs, and your neighbor across the road decides, hey, I like what's going on there, it looks like he's doing well, I'm going to contract feed for the same owner. Completely separate operations, you have nothing to do with each other except you were going to contract feed for the same owner. The DNR interpretation before was that was common management, and your two operations were together, and you had to count the animal units together, and it meant that you might have to get a permit if your neighbor was feeding for the same owner. The rule has changed. And open feedlots have never been added together under that rule, and the deep-bedded cattle barns, when the law was changed a couple years ago, were excluded. And this rule now puts everybody on the same page. As you can see here, I've underlined it. This does not, common management does not include control by an owner of animals being fed under contract. Okay. So that was a real gotcha, in my opinion, that got some people in years past, caught them where they didn't realize that operation would be considered common management with the other one. I think this is a real, when I said there's some good things in these rule changes, this is one of the biggies. I think it makes a lot of sense. It is a rule that, in my opinion, should have been that way from the beginning, but we've got it changed, and I appreciate everyone's work on that. So now we're again, a good rule change that it should help a lot of people to avoid some unfortunate situations. Okay, I'm on slide 7. No changes here, but we're seeing a lot of 1,200 head buildings built, small animal, 1,200 head finishers, wean to finish, or feeder pig to finish. This is the small animal feeding operations. What do they have to do? Really 4 things there. I'm not going to go through those in detail. I'll have some more on this a little bit later on stormwater discharge permits, but that first bullet point there, you have separation distances to water bodies and wells. What's missing there is separation distance to neighbor's house. You do it for these size operations, the small ones. Iowa law does not require separation distance. I would encourage you to still look at meeting those separation distances for several reasons. One, in my opinion, the law says if you expand later, you need to be that far away, go above the small animal feeding operation threshold. I know there are some others who think you are still exempt, but I believe that's number one. But number two, the last part of my talk today, nuisance, we have an example of, and have had over the years, where these buildings get built and they comply with DNR regulations, but they're less than the 1,250 feet from a neighbor's house, and then a nuisance suit is filed. And just because you had an exemption to the distance under DNR regulations does not mean you get an exemption from a nuisance lawsuit. So I encourage everyone to take a close look at these separation distances, even for the small operations. I'm not saying don't do it and don't use it, just take a close look at it. Okay. Now we're into the 500 to 1,000 animal unit size, the next size up. For hogs, 1,250 head to 2,500 head. There has always been a construction approval letter that you receive from DNR, and I have it underlined there. DNR has clarified in the rules that that expires, that approval letter expires if you don't start building within 1 year and if you don't complete it within 4 years, similar to your construction permits. I'm going to keep moving here to get through as much of this as I can, and nothing new on this slide. I just wanted to put it in there for your information. Slide 10. Okay? New DNR rule. Underlined there. Now we're talking about the size of site that needs a construction permit from DNR. 1,000 animal units and larger. 2,500 head for finishing pigs, sows, etc. Rule says permit application should be submitted 120 days before construction is planned to begin. The word is should, and that's a recommendation, not a flat requirement. So, and I think it's a good idea if you can do it, but it's not a requirement, it's a should. I just wanted to make sure that that was clear. Then the next one. I mentioned this briefly in the intro, and I wanted to cover it here. For quite a few years, if you build a non-permitted site, say you build a 2,400 head finisher, then you decide, hey, I want to add another 1,200 head building, be 3,600 head, that kicks you up over the threshold to need a permit, and you, under previous rule, DNR rule, you had to wait a year. And what I ran into quite a bit was, producer starts on the 2,400 head site, and then gets financing becomes available, or gets a contract that allows him to raise him or her to raise more pigs. So they want to get that 1,200 head, that second one, built right away with the others, but they had to wait a year unless they could get a variance from DNR. That 1 year waiting period has now been changed to 120 days. And again, I think that is a very good rule change for us. Put a star by that, because that one, it caught people off guard sometimes about the waiting period, but the reduction of that waiting period should be a big help to us. If anybody has any questions or comments as I go along, please feel free. Raise your hand as we go. That's the time to ask a question. Okay, slide 11. If you're on a permitted site, and there are changes to the construction as you go along, the DNR rule that I have underlined there says any changes to design during the construction must be approved by DNR first. The previous rule allowed some leeway that you could, if there were changes, you could, your engineer could point those out to DNR at the end of the process. Now it makes it clear any changes must be submitted and approved by DNR before those changes are made. I don't know if that's going to cause many problems during the construction process. It might, but I think the key is get a hold of DNR, talk to them about it, talk to the approving engineer. And right now, Gene, the engineer that approves almost all animal feeding operation permits is Paul Petiti. Is that right? Contact Paul directly. Yes, sir. Okay, question is, I have a slide here about the floodplain and navigable rivers and how many. There's quite a list. It's it's in the DNR rules. There's a list of the rivers that are considered navigable, and the stretch, like it'll give you a description of where they are in the county. I don't have any idea how many, but that is a big issue for anyone who is building. You got to take a look at that list, and you have to get this. You got to be sure you're not in a floodplain, and it happens more than you would think. The question was on the smaller units. Are you talking less than 500 animal units? The question is, how do you determine if you're in a floodplain, right? Or because to determine if you're in a floodplain, you have to first see if you're on alluvial soils, and then if you're on alluvial soils, you get a determination from DNR. My advice is go to the map that's on the website, and then take a look yourself. But if you have any questions, contact DNR or contact a consultant. The builders often are very aware of this, but get some help on making that determination before you go forward with that small site. And this, I wanted to introduce, this is Kent Maurer, who, with the Iowa Coalition to Support Iowa's Farmers. Many of you have worked with the coalition in years past. Kent, you've been in this position working with producers now since?
6 months.
Okay. Please feel free to ask Kent questions, and work with Coalition has a booth upstairs, so please stop by, and I appreciate Kent stopping by this morning. I take it, Kent, by you asking me that question, you've had to deal with that in working with producers.
Yeah, I just wanted to...
And there may be some of you out there who have dealt with this more than I, and Gene, chime in here, but the map is where I tell people to start. And it's like a lot of things. If you look at the map and then you determine that I'm not even close, I've got quite a ways, fine, I think the map is sufficient. If you're right on the edge, I'm not saying, yeah, get some help then, because you don't want to put that building up in a place it shouldn't be, and that's where I think DNR can help, or an engineer, etc. Yes, sir. Okay, sir, I want to stop and repeat what you just said, and then for the tape. The gentleman just said FEMA, Federal Emergency Management Agency, is changing the floodplain maps as we speak. Is that correct? Now, can I stop you there? Gene, maybe you don't know, and if you don't, I understand. Does that change the DNR maps then, too, for the animal feeding sites? Okay, and Gene said it will change what DNR uses for the 100-year floodplain, but Gene accurately points out, you got to start with the alluvial soils first, because there are sites that are on alluvial soils, and if you are, you have to get a floodplain determination, but that just because you're in alluvial soils doesn't necessarily mean you're in a floodplain, so that's the next step. Go ahead, sir, with you. And the gentleman reminds us that there was a legislation proposed last year in the Iowa legislature that would have, by going to changing the 100-year floodplain would have greatly expanded the areas that would come under the prohibition, correct? And that bill did not pass. And the bill was not aimed at livestock. It was a result of the flooding we've had in the recent years, 2008, and the effect on cities, etc. But as the gentleman here has pointed out, that could have a big effect on us. So we as livestock producers need to keep an eye on that to see if it comes back this year. Is that accurate? All right. Thank you. Okay. Any other questions on this slide 11? I guess. Gene points out that the person in the Iowa DNR that makes that determination is Claire Ruby, and Ruby is spelled H-R-U-B-Y. Find her on the DNR website. Claire is very helpful, and she's the one that if you get a hold of Gene, he'll refer you to Claire, so just get a hold of Claire directly if you can. But, of course, Gene will always take questions about it. Thank you. All right. Matrix issues. 1,000 animal units or more, you need the matrix. Except my favorite subject, exemptions. You're not required to have the matrix if your expansion up to 1,666 animal units if the site was there before April 1 of 2002. Of course, as the years go on, we don't have near as many of those. We're coming up on 10 years now, I guess. But always take a look, because the matrix is something that, yeah, we have a lot of producers who pass it. It can be dealt with, but a lot of producers would just soon not have to deal with it. They don't have to. So make sure you're required to have the matrix before you go through that work. Okay, slide 13. What is the owner of a site? We've had issues with this in years past on some appeals to the Iowa Environmental Protection Commission. When someone applies for a permit, here's the situation. If you're going to buy a site to put up a hog building or whatever building, you probably don't want to actually buy that site till you know you're going to get a permit, right? So oftentimes you would enter into a contingent real estate contract, I will call it, where you agree to buy it, price is all set out, but it's contingent upon you getting a permit. So you really don't have legal title yet. It's what we attorneys would call equitable title. And if someone, after you submit your permit application, because the owner is the one who has to submit the permit application, if after you submit it, someone who, let's just say, for instance, may not be overly enthused about you building that site where you're going to build it, if that someone goes to the county recorder's office and looks up the owner, your name won't be there in most cases because you haven't acquired legal title yet. And that's what we've run into, where it has been alleged that, hey, you're not the owner, you can't get the permit. So this clarifies it. I think another very good rule change. It says the owner means the person who has legal or equitable title. So a purchase contract contingent upon a permit being issued should qualify you as the owner, and we shouldn't have any more problems here. Famous last words probably. But anyway, we've got a good rule change there. Okay. I'm going to skip over this slide. Slide 14 talks about who needs a construction permit, and even if you don't have physical construction, if you increase the animal units or increase the number there and go over a permit threshold, you still need a permit. Can be a big issue. I'm not saying by skipping over it it's not important. I just need to focus on the rule changes. Okay. Slide 15, this is for the earthen manure storage. If you are applying for a permit here, you need a soils permit or soils report with your permit application. You'd be working with an engineer there, of course. And the rule has changed, I think, just to put, primarily to put DNR policy in the rule on these lagoons and these earthen basins. And there's a lot of them out there, and you just need to be doing a good job of controlling berm erosion. The rule says perennial grass on the outer, the top, and the inner, down to the freeboard line of the berm, unless you have the areas covered by concrete, rip-wrap, or synthetic liner. But the one thing as some of you know, I represent a fair number of producers who have run afoul of the DNR, and there's an administrative order in place, or being proposed. In other words, they're being fined by DNR. And one of the things I see of the cases I have right now, a good number of them are earthen lagoons or basins, and it may be an issue with not meeting freeboard or something like that, but invariably somewhere in there there's a state, the DNR field officer has noted the berm's not in good shape. There's real erosion, there's rodent holes, etc. If you have these lagoons or basins, please pay attention to taking good care of them. I know we're all busy, and it may not look like that's a big issue as to whether that stuff's going to run out of there or not, but it is an issue to keeping those in good shape and staying in good stead with the Iowa DNR if they come around for an inspection. Stormwater discharge permits, slide 16. Nothing's changed here. I just remind you, if you're going to disturb more than an acre in building anything, this doesn't just apply to hog buildings, anything other than field work, terraces, etc. But if you're building anything, as far as the building goes, machine shed, whatever it is, and if you're going to disturb more than an acre, and by disturb I mean either tear it up or pile dirt where there wasn't dirt before, what I usually say, if it was green before and you're turning it black, however you're doing it, putting in a driveway, whatever it is, if that adds up to more than an acre, you need a stormwater discharge permit. And I give the process here is how to do it. It's just some people get caught with thinking, okay, we aren't going to tear that much up, but you get into the dirt work and you decide you got to move more, or you build a driveway here. What usually happens, neighbor complains about something, DNR comes out and they have to check. Gene has pointed out there is a process here for, let's just run through this. You publish a form notice in 2 newspapers with the largest circulation in your area. That's just a form that says, and DNR has a form on their website if I remember right, pretty standard. You just give notice that I'm going to be building something here, and you give the receiving stream and where it's going to be. That goes in the paper. Next point is prepare a pollution prevention plan. Again, there are forms out there that we can help you with. You just have a plan in place. You're going to check after rainfalls of, more than half an inch, I can't remember, that check for runoff. This whole pollution, stormwater discharge permit and pollution prevention plan is about stopping erosion from construction sites when that ground is exposed. So you get a pollution prevention plan. You have to have that in place. You don't submit that to DNR. You keep it on site. You publish your notice in the paper, and then you can submit a notice of intent to be covered by the state general permit. But we come back to, this is all the paperwork, and what Gene is pointing out, in your pollution prevention plan, if you say I'm going to put round bales, big round bales in the areas where it will drain, or the silt fences or whatever, you need to do that. You need to be controlling that erosion, because just having this piece of paper, and if DNR comes out, or if anyone sees erosion occurring on that site from your construction site, you've still got a problem. So you need to put the procedures in place to control erosion, and that needs to be done until the seeding is established, a permanent seeding on that site. And what I've run into also on this, you can get them for a year or 2 years or whatever, and you get it for 1 year, and then 1 year is up, but you still haven't got a seeding established. So some people go ahead and get them for multiple years to start with, because they're not sure when they're actually going to get that seeding established. Any questions on pollution prevention plans? Separation distances, again, nothing much new here. I'm going to run right through this. There are charts on the DNR website, distances to residences, etc. Luckily we have, I will back up. Very good DNR worksheet there. I give you the website at the bottom of slide 17. Exemptions, page 8 or slide 18, written waivers. Many of you are able to work with your neighbors, and if you can't meet the distance, you can get a waiver from the neighbor. Some practice pointers, I would call them, about what maybe to put in that waiver. And road rights-of-way separation, 100 feet from the right-of-way. The exemption is for small animal feeding operations, or you can get a waiver from whoever has legal authority over that road, and believe it or not, we have gotten those in a few instances. Okay, water body separation distances, I'll leave those to your reading. Again, I want to try and make sure we get through I want to get to the EPA NPDES permit slides this morning as much as we can. So again, I'm not saying these that I'm skipping over are unimportant. I just, if you have questions, let me know. But I want to focus on the rule changes this morning. Slide 22. Here we're talking about secondary containment. If you have to be 500 feet from a creek, and we have a lot of places in Iowa, at least you notice how I said the word creek there? That's not, usually it's a creek to me, and Bob out there knows where I'm from, and where I'm from it's a creek. But I gave one of these presentations one time, and somebody asked me if I had a problem with my neck. I kept talking about a creek. But it's a creek, and you got to be 500 feet from it, and there are a lot of those down where I'm from, southwest Iowa, near Atlantic, and getting 500 feet away sometimes is a problem. What can you do? You can put in secondary containment. For confinement buildings, liquid storage, here's not the easiest thing to do with the secondary containment, but it can be done. I'm not suggesting to do, to voluntarily get closer than 500 feet, but I'll give you an example, our home farm. If I don't have a confinement building there, maybe someday, but I've got a creek on each side and 500 feet, there just isn't any, you got to kind of go back in the field a ways as those creeks go like this where you can get a building in there. Okay, so if you don't have any options, you can take a look at doing this. Here's the requirements for it. Most people shy away from it for liquid, for confinement buildings, because storing, getting that secondary containment in place is the requirements are an issue, plus maintaining that has been a real hassle. Why has it been a hassle? Slide 23, we have underlined there. It's been a hassle because the rule previously said you couldn't have any outlet. You build that berm, that secondary containment, and I called it a berm because the DNR specs pretty much make it a berm. It's going to hold water, or at least it better hold water. And if you get runoff in there, you got to do something with that all the time. Hopefully we'll never have any manure in it, but you couldn't have an outlet in there. All right. Here's what the rule says now, and I want to go through this carefully. I know many of you don't deal with this, and Jeannie and I have talked about this, and I think we're all on the same page here. First of all, the rule says you can have a relief outlet or valve, right there. But then the next part of the rule says it must remain closed. Well, my first thought when I read that is, boy, that was a big help. We can have a valve, but it's got to be closed. And here's the way I read the rule. Yes, it has to remain closed. The point is, if you have a valve there and left it open all the time, chances are pretty good that if you ever had a problem, that valve would be open and the secondary containment wouldn't do any good. So it has to remain closed. Then the rule says, and any liquid due to overflow must be land applied according to your MMP. So, it has to remain closed. If there's liquid in there, and any of that is manure from an overflow, then you do have to pump it out and put it on under your MMP. But the other side of it is, which the rule doesn't specifically say, if it's not from an overflow, if it's just runoff that's in there, if you've caught the rainwater or whatever in this secondary containment, you can open the valve and let it go. Right, Gene? Okay. Make darn sure when you open that valve there's nothing in there, okay? That it's just runoff, nothing from the building. So, again, I think a big help to those areas of the state where we need to put the building there, not your first choice, but if you don't have another choice, this rule change makes this secondary containment a lot better to deal with. Dry manure storage for these cattle, dry-bedded buildings and hog buildings, it's you only have to contain 10% of the manure stored inside. You don't have to meet the percolation standards, etc. A lot more workable for the dry manure buildings. Gene, anything to add there on secondary containment? Have you dealt with it much since the rule change? Have you had any requests or anything? Okay. So the cattle barns? Okay. Slide 24, manure management plans. Couple of rule changes here, and we have some manure management planners here today for plans submitted, either updates or new ones after September 15, 2010. The dominant critical area determination changed, and it's now under NRCS technical note number 29. I'll not go into any, if anybody has any questions about that, probably the people to ask are sitting back there and not me, but that is a change in the rule as to how you, this is for the phosphorus index, of course, and how you determine the dominant critical area, and it's now under NRCS Tech Note number 29, actually in the rule. Here's another, this is the next one on my slides here. I'm pointing to it here on the overhead. This has been a DNR policy for a number of years now. It's in the rule. If you sell an operation, confinement operation with a manure management plan, the new owner has to have a new MMP in place within 60 days after the transfer. However, you can use the existing manure, the new owner can use the existing manure management plan for manure application until then. So if you sell a site, October 1, need to apply manure in the fall, that new owner can go ahead and use the existing MMP for that 60-day period, but within 60 days, the new owner has to submit a new MMP. Gene's question is, if I, as the previous owner, have a manure application agreement with Gene, and then I sell to Jay over here in the corner, and does Jay, do you have to let Jay apply manure on your land? It depends on what the application agreement says, Gene. You need an attorney to review that carefully for you. So, I got Paul's attention with that one. It truly does. Now, I don't know how the DNR looks at it, but under the contract law, under that manure agreement, it depends on what the agreement says, and a lot of agreements say that it can be transferred and that or assigned, and that you have to allow the new person to apply. But it truly does depend on what the agreement says. And I assume DNR I know I've had that issue when I've represented some clients who did transfer sites, and the department has wanted to see new manure agreements, but I've said, well, here's the old one, and read where it says it can be assigned, and then that's been fine. Okay? All right, good question. Don't worry, Gene gets his ways of putting me on the spot when but again, these are the kind of things we all deal with in practice out there. Annual updates of manure management plans. DNR is no longer sending reminder notices of the due date. That's been in effect for about a year now. Is that right, Gene? And I hope everyone's getting their own record tickler systems in place to keep track of that, because you no longer get notices from DNR. Now, DNR, do they still send a notice? Some of you can help me out here. When the P-index update is due, which is every 4 years, when you have to have a new P-index, do they, I was thinking no, I'm getting a no. They don't send a notice for that either. Okay. No notices for any of the due dates. You have to keep track of this yourself. So just be aware of that. I do think DNR sent a notice out that said they weren't going to send any more new notices, right? But people get busy, and I've had a few calls that it was a surprise to them. I think you'll work with them too. My understanding and my experience is if the MMP is due the first of the month, the update, generally no action is taken until the end of the month. Is that safe to say? Gene said the 15th, 30th, somewhere in there. Don't push the envelope here, folks, but if you run into a jam, it was due the first of the month, you don't have it in, where we really hit the problems, and these guys who do manure management plans will tell you the problem is when you need a P-index update, so you need soil samples that you haven't taken, and it's along about September 1st or whatever, and you have to go out into standing corn or beans to do that. That's where it's this time of year where the ground's froze. First of all, try and avoid those situations. If not, I've found hopefully you can get something worked out where you can get it in as soon as possible. Am I being sufficiently vague there? Okay. The compliance fee, I had a question about this the other day. If you're contract feeding for someone else, the question was, it's time to do your P-index update. Nothing's changed. No new land, but the law says you have to have new soil samples. They're only good for 4 years. So you have to go out and do new soil samples. And your question was, do you have to submit to DNR the whole packet or just the updated information? And Gene's answer was the whole packet. Okay? All right. I talked about the compliance fee for a little bit. Contract feeding, if you're feeding for someone else, the law says the livestock owner is required to pay that fee. DNR just leaves that up to the people to work that out themselves, right? I'll say it this way, Gene, you can disagree with me if you want, but as long as DNR gets the 15 cents, they don't care even if the attorney pays it for them, right? They especially like those checks. Okay. Yes, sir. Okay. The question was, for doing the MMP, for getting that submitted to DNR, taking care of all that, if you're taking manure from someone else, but it's not your operation, obviously, you own the land where the manure is being applied, the question is, who's responsible for taking care of the MMP and everything with DNR? DNR will look to the owner of the operation, whoever his name is on that manure management plan or that permit with the manure management plan. DNR looks to them as the responsible party because they have the operation. That's who DNR looks to. Now, I don't see this very often, but once in a while you'll see an agreement between private parties where the owner of the operation will say, I want you to take care of it as the owner of the land. Very rare to see that, but DNR doesn't care about that. They look at whose name is on the manure management plan. Okay? Did I answer your question? So we have an owner of land here who had to do the MMP. But anyway, that's how DNR looks at it under... I keep coming back to this, but the regulations, DNR regulates the operation, whoever has the MMP, etc. The owner of the land that receives the manure really isn't subject to DNR regulation as far as rates, etc. like that. Gene? Okay, I think, again, Gene is saying DNR has authority, quote-unquote, jurisdiction over the livestock producer who has the MMP, etc. They don't deal with you directly, but you may have to, you as the landowner that gets the manure may have a private agreement between you and the building owner or the livestock producer, but they're going to look to the livestock producer. Okay? All right. We've talked about the phosphorus index, record keeping for manure management plans. In the interest of time, I'm going to move through this about the statement for commercial manure application, etc. Manure applicator certification. If you're a confinement site manure applicator who misses a course 1 year, you must pass the exam to remain certified. So the key there is don't miss your certification where you take the instructional video or whatever. Then you're going to have to take a test. I'm going to, again, in the interest of time, move through some of these. Again, I'm not saying they're not important, but I want to get to some of the other issues here. And we're here, slide 29. In the past, and I'll say it again, we haven't focused a lot on EPA and Clean Water Act, NPDES permits. If I was giving this talk to cattle feeders with open feedlots, that would be, we'd spend a couple hours on that. And this slide, I think, sums it up. Obviously, I think it does. I did it, but maybe it doesn't sum it up to some other people. Confinement operations, I don't care if it's a hog building, poultry building, etc. Look at this third bullet point. Iowa law says you cannot discharge. Nothing gets to leave that pit, that lagoon, whatever. There's no such thing as you get to discharge in a 25-year, 24-hour storm like a cattle feedlot can if they have the proper NPDES permit in place, etc. No, Iowa law says you can't discharge. So why on earth would I then get a permit, a discharge permit, an NPDES permit, when I can't discharge? Now, I know this is going to be on tape, and I'm sure I'll get, but I've said this before, and I'll say it again. Iowa law prevents you from discharging, so why would you get a permit to discharge when you can't discharge? To me, it's a big circle, and it's a waste of time. But we're seeing a lot of interest by the federal EPA right now in Iowa looking at mainly combination operations, some confinement buildings, and they're doing flyovers. They're getting in an airplane and flying around looking for livestock buildings, etc. Right now, there's still, the cases I'm aware of, they're looking at where there's a small open feedlot and then a confinement building, and we'll talk about that in a minute. But folks, we're under the microscope here. They're working hard on cattle feedlots to get them into compliance, to get NPDES permits in place, but they're taking a look at us now too, us being the confinement buildings. And my advice, there's new rules that DNR has proposed right now to put the process in place that if you as a confinement operation want an NPDES permit, you will be able to do that. And it's just, I can sum up those rules and pretty much very easily, and that is, whatever the federal law is, that's the law in Iowa. When do you need an NPDES permit? This third bullet point down here, I need to say. There it is. If you discharge or propose to discharge, and that is if you are designed, constructed, operated, or maintained such that a discharge will occur. I don't think we have confinement operations like that in Iowa. Gene, anything I've said you... go ahead.
What's a discharge?
Okay. Gene always never lets me get off easy. All right, we've laid the groundwork there, so to speak. Slide 30. Well, I'm talking about the operation itself, your confinement building. Gene says, what's a discharge? Under federal law, and pretty much state law, a discharge, well, hold it, I said that wrong. What would require you to get an NPDES permit or be in violation of the Clean Water Act? If manure gets from your confinement building to a water of the United States or a water of the state, okay? That's what we're talking about. So some manure, excuse me, that you have a pump, you're agitating, hose breaks, and manure gets out on the ground right outside your building. Technically, that's a violation of Iowa law because Iowa law says you have to keep it in the structure. But that's not a violation of the Clean Water Act because it didn't get to a water of the United States, okay? Okay. Now, what about land application? What if you have a discharge when you're applying manure out on the out in the field, because that is included as a discharge. But there's an exemption in federal law for what we call ag stormwater discharges. And what is an ag stormwater discharge? If you're exempt, you can have a discharge from something that's called ag stormwater discharge, and to get that exemption under Iowa and federal law, you have to, if you're applying manure and you get a heavy rain right after you're done, you're still okay if you apply it according to your manure management plan, that if you put it on rates according to that, you're still okay. Now, so we've covered that situation, I think. Let me go to the next one. What about an accidental discharge? What are most of the discharges we have in Iowa from a confinement building that are land application related, or when a hose breaks, something like that? That's an accidental discharge. Does that require an NPDES permit? Here's what federal law says, and we're incorporating this into Iowa law, right, Gene? If the cause of an accidental discharge that has occurred in the past has been changed or corrected, the CAFO would not be considered to discharge or propose to discharge, and an NPDES permit would not be required due to the accidental discharge. For confinements, this is the whole ball of wax right here when it comes, in my opinion, when it comes to an EPA/DNR NPDES permit. If you have an accidental discharge, and we have some every year, what you need to do, and first of all, you will probably get a letter from Iowa DNR that you have violated Iowa law. There may be a penalty there for having a discharge if that hose breaks or whatever happens. But that still doesn't, in my opinion, and I think it's clear under the federal rules, doesn't require an NPDES permit, but you have to change or correct the condition that caused it. So, if you have a hose break, you need to implement a procedure that says, I'm going to check those hoses more often. I had one producer who unfortunately had the agitation pump that they were hauling, didn't have anybody at the pump, and this has happened to more than one. Hauling out in the field, didn't have anybody stayed with the pump moved, agitating while they were gone, started shooting over the edge of the lagoon or the pit or whatever, and had a discharge. What do? We paid our DNR fine, but we stated right in the order that one of the things we were going to do as producers was to keep somebody at the pump at all times to make sure that that was not left unattended and that couldn't happen again. We changed and corrected the condition that occurred. Okay, any questions about that? Gene, anything? Okay, I want to just sum it up a little bit here. You're going to hear more about these rules. They'll become final, what, spring? Yeah, somewhere in there. And again, they are, unless something drastically changes, which it can't, because the Iowa law says these rules can't be more strict than federal law, and federal law says they can't be less strict than federal law. So guess what? They pretty much have to be what federal law is, and federal law, there's no change on the horizon there anyway as far as rulemaking. So my advice to confinements, and I may, each situation is different. I'll throw in all my disclaimers there. I still don't believe Iowa confinement operations, deep pit, even lagoons, I don't believe need to have an NPDES permit, because they cannot discharge according to Iowa law. And if you are careful during land application, and because even if you have an NPDES permit and have a hose break during land application, your NPDES permit doesn't cover you there for having the discharge. All it would do is save you from a penalty for not having an NPDES permit. There, have I talked in circles enough on that one? Okay, any questions on the NPDES permit issue? Because I know you'll be hearing about it. Okay, there's a no discharge certification option, and that is, again, it's there for you. I'm not going to spend too much time on it. If you have questions about it, I'll be glad to visit with you afterwards. It's available under federal law. All right, here's one of the things we're hearing from EPA. I talked about confinement buildings, and I couldn't imagine why you'd want a NPDES permit because you can't discharge under Iowa law. Well, guess what EPA says in their guidance document? What if, and this was issued last spring, it's on the EPA website, what if and they show a picture in that guidance document of a poultry operation with feathers laying out on the ground. Where'd those feathers come from? They came out the exhaust fans. And here's what EPA says. Whether pollutants exhausted by ventilation fans will then be transported in precipitation runoff to waters of the U.S. If so, EPA takes the position that the facility is proposing to discharge and must apply for an NPDES permit. That's where some of this is headed, folks, that EPA is proposing to look at what comes out of those exhaust fans. Now, I don't think you're going to have any feathers coming out of these hog buildings, but dust, particulate, out on that ground, outside your building, and where does that, even if you have a lagoon outside, usually you don't have that area drain into your lagoon because you don't want it filling up with runoff water. So the question will be, is that a pollutant out there laying on the ground? And if it is, does that require an NPDES permit? Well, EPA's position is that when it runs off, it goes into either goes right into a tile line somewhere, a ditch or whatever, or you may have a stormwater drainage system, but ultimately, if it ends up in a water of the United States, that's pollution. I suppose I better be careful what I say here, but folks, if we're headed towards violations of the Clean Water Act because there's some feathers out there, I'm going to be busy for a long time because I think it's ridiculous. Now, granted, can we have significant exhaust or pollutants get out of those exhaust fans, dust from our hog buildings? Many of you are using biofilters, etc. I just have a hard time with this, and we'll see where it goes, but I'm just telling you what EPA is proposing. Gene? I'll be careful how I repeat what you said, but what you have said is, I think what you're saying is, as a result of this position they've taken in the guidance document, they have gotten, let's use the word feedback. Okay. And as a result of that feedback, it appears they're reevaluating the situation. How's that? Okay. I'm not trying to say run out there and get an NPDES permit because you've got some exhaust out of your building fans. Far from it. I'm just saying this guidance document lays that out there, and I appreciate Gene being here to say it appears that is being reevaluated. So stay tuned, folks, because this confinement issue and NPDES permits just leaves me scratching my head. I can't figure there are a lot of things we need to do to be good environmental stewards and to comply with regulations, but having a piece of paper, an NPDES permit, that says, tells you when you can discharge, and when that piece of paper says you can't discharge, I don't get it. I don't get it, because Iowa law says you can't discharge. So, enough. I'll get down off my soapbox. The guidance document talks about mortalities, etc. I'm on slide 38 now, and I don't want to go too far over, but I do have some things. I'll just keep going through here, and I'll probably try and wrap it up in the next 10 minutes. How's that? Okay. Combination operations. Now, by combination, I can talk about combining species, hog building, cattle yard, or how about hog building and hogs outside. That is a combination confinement and open feedlot. I have a slide here, and primarily I've used this when I've given this talk for cattle producers, but just a little background on how EPA rules do not distinguish between a confinement and an open yard. To them, it's all the same thing. Okay, they don't look at totally roofed versus partially roofed, unroofed, etc. So, what we've gotten into, Iowa law has always distinguished between them and regulate confinements differently than open feedlots. But when it comes to NPDES permits, if you go over that threshold with all hogs on one site over 2,500 head and that needs an NPDES permit if you discharge or propose to discharge, if you have a confinement building there of 2,400 head and say 300-400 head outside, well, your 2,400 head aren't the problem, but you have to add in the outside hogs, and therefore you're over the threshold, and EPA, in doing their flyovers, will see that, and this is what they're focusing on, folks. They're looking at those 300 or 400 head hogs you have outside. Are you controlling the runoff from that site? And are you, because you don't have an NPDES permit, you can never, ever, ever let any of that get into a water of the United States. And that's where they're getting people. A lot of cattle yards have built confinement cattle buildings with an cattle open feedlot there, and may not have gotten an NPDES permit. They're required to control the runoff from that open feedlot because you add them together. That's it in a nutshell, what we're running into. If you have that situation, you need to be taking a close look at that outside lot to make sure you're controlling that runoff so that that doesn't get you in the soup, so to speak, with EPA and DNR. Now, let me get to slide 41. Do we add the animal numbers together? If they're all hogs, they're added together, okay, under federal EPA rules. But if they're hogs and cattle, they don't get added together, all right? Gene's looking at me. He's waiting for me to say the next part of it. So again, I want to say that if you have confinement hogs and outside cattle, you don't add those together to determine if you need an NPDES permit or not. That's federal law. But what if you have, see, 2,500 head is the threshold here for an NPDES permit. What if you have 2,600 head of hogs and then 400 head of cattle outside? I just said you don't add them together. But look at this bottom slide here on slide 41. Oops. Bottom bullet point. Once you trigger the NPDES permit threshold for one species, like hogs, you triggered it because you went over 2,500 head. Well, you don't worry about it because that's confinement. And I just told you confinement shouldn't have to get an NPDES permit. And I just told you don't add them together, but you have to add them together. You have to add the cattle in if you triggered it in one of the species. If you didn't trigger the 1,000 animal units in any of the species, you don't add them together. But if you trigger it in one, then you have to add everything in that's on that site to determine if you need an NPDES permit. If I made that more confusing, I apologize. And we'll be covering that in our environmental handbook. There's the categories on slide 43. I'll leave that to your reading. I want to get through the rest. Medium CAFOs. In general, under federal law, if you're less than 1,000 head of cattle, you don't have to worry about you're not a large CAFO and you don't need an NPDES permit. Well, EPA last spring did, remember what last spring was like when the snow was melting? EPA did some flyovers and they saw some cattle feed yards that were less than 1,000 head that they thought were having some significant runoff problems, but they were less than 1,000 head. Well, here's the key issue in Iowa, slide 45. Whoops. There is an issue if you're less than 1,000 head, and the federal law says if you are transporting waste to a water of the United States through a man-made conveyance, then that makes you a CAFO subject to NPDES permits. EPA takes the position that a road ditch is a man-made conveyance. If you're having runoff from that feedlot that gets into a road ditch and then gets to a water of the United States, they are taking the position that that's a man-made conveyance that then triggers you, even though you're less than 1,000 head, to be required to have an NPDES permit. Here's one where I've looked at this carefully. It's a close call, but I don't think a road ditch was ever intended to be considered to be a man-made conveyance. EPA strongly disagrees with me, and they are taking action against these feedlots. Thus far, they have not penalized anyone, right, Gene, that I'm aware of, but they have ordered those feedlots to get an NPDES permit. So that's the road ditch issue if you're less than 1,000 animal units. Haven't run into it for hogs yet, but you could if you had an outside lot that drained into a road ditch. Okay. Yes, sir?
One question. Then is a waterway a man-made conveyance?
The question, Kent's question is a grass waterway? Gene and Kent love to sit here just no, that's a very good question. I was going to duck it because there is no good answer, but I won't duck it now that he's brought it up. Got a cattle feed yard, and it's less than 1,000 head, drains out into the field, and you build a nice grass waterway for that drainage coming off that feed yard. If that drainage comes off that feed yard, goes through that grass waterway, and gets to a water of the state, Kent's question is that a man-made conveyance? Well, it was man-made. Again, I don't think it is, and to my knowledge, EPA has not yet taken that position. That's the last I knew. Gene, are you? Remember those gray areas I talked about? Or maybe you weren't here yet, Kent. But this issue of what is a man-made conveyance, folks, I went back to the Clean Water Act was put in place. There were Senate hearings as early as 1973, somewhere in there, and I've looked at some of those minutes, etc. And EPA, again, will strongly disagree with me, but I don't think the intent ever was to have, I think the intent was a specific conveyance that was built to transport waste. And Gene, I agree with what Gene said. It's a tough call for a grass waterway. What did you build it there for? And if it's directly from the feedlot, a grass waterway down to a creek, I think there could be problems there. But grass waterways are the right thing to put in there. Rather than not have one there, it puts our producers in a tough spot. And Kent, I know you're out there talking to them day in, day out. I think they have to exercise extreme caution when putting in grass waterways and those sorts of things. EPA would say the answer is just put in a containment basin and you don't have to worry about it and get an NPDES permit. Now we're into manure application. I just wanted to talk about manure application on frozen or snow-covered ground. We all know the legislation that went into effect on July 1 of 2009, new rules that went into effect in September for this year. One of the rules, I'm on slide 54, clarified that frozen liquid manure does not qualify as dry manure. Dry manure is not subject to the emergency notification requirements. And Gene, we've clarified in the rules that just because that was liquid manure that now can't be pumped through a pumping device, which is the definition of solid manure, because it's frozen, that doesn't mean it's dry manure. Also, again, I won't go through the details of this legislation or the rules in the interest of time. We have a lot better year this year than we did last year as far as the amount of manure that needs to be put on. But there are some exemptions. One, open feedlots are not subject to the emergency notification provisions here, so any manure from an open feedlot is not required to do the phone calls to DNR, etc., required to be an emergency. But, and I want to emphasize this over and over again, all manure, I had a slide here previously, has to be applied so that you don't cause water pollution. So if you're open feedlot, you're putting scraped solids from that feedlot out on the snow, you can do it. You're not required to notify DNR, but if you have runoff into a creek, you've still got a problem because you're subject to the state and federal law that you can't have runoff. So it's not a free pass. You're not subject to the emergency notification requirements. We have the definitions here, frozen and snow-covered ground. I won't go through those. Also exempt, what if you have a confinement operation that has solid manure, poultry, hog hoop building, etc.? That's not subject to the emergency notification provisions, and you can apply that on frozen and snow-covered ground, but again, you cannot have runoff. Okay, what is an emergency? Unusual weather conditions, we had those last year, kind of be a little hard to claim those this year, I would assume. And equipment structural failure, equipment failure, most of the time we consider that to be a broken water line. And your pits fill up and you need to get it out in the wintertime. I think the point Gene made there about calling in, if you're a small animal feeding operation, if you have solid manure, if you're an open feedlot, if the neighbors see you out there on snow, and some may think well-intentioned, some not so well-intentioned, will be inclined to call DNR and say, hey, they think it's a complete ban, some of them. Some of them just want to get you in trouble. But if you're exempt, and DNR gets a call and they've not heard about it, they'll come out. It's a waste of their time, waste of your time. If you call them ahead of time and say, hey, I'm going to be putting on, I'm less than 500 animal units, or I'm an open feedlot or whatever, they can remind you of some of these requirements Gene just talked about to be careful. But also when they get that phone call, they can say, oh, well, that producer's contacted us and they're okay. So I think can be a big help. Okay, slide 58, the new rule that has received a lot of the attention in the last, since it was adopted in September, is this not having enough storage. Primarily we're seeing this with dairies, but some hog operations, that if you are an existing operation as the date the law passed, and you don't have enough storage to get through the winter, you don't have to build new storage now. until 2015. You have roughly 5 years to build new storage, because after that, not having enough storage will not be considered an emergency condition. And you, as a liquid confinement, would not be able to put on frozen or snow-covered ground even by calling DNR. Right, Gene? Anything to add there? So, okay. I went way over my 5 minutes. It's now 25 till. Again, I think I'll try and wrap it up here shortly. I don't think I have anything major to add. Stockpiling dry manure, I'll leave that to your reading. I'm on slides 60, 61, 62. Appeals of DNR construction permits on slide 63, how an appeal is handled with the EPC. We cover that in more detail in the handbook. Just I hope you're not in this situation where you have to deal with an appeal, but the appeal requirements have changed some, what you have to present at the hearing. Slide 64, open burning. I've talked about this before. This is just one of these I throw in. I do a lot of work with producers who have been visited by DNR and may be facing a fine or a penalty for something. And one of the things that a DNR field officer will look to see, if you have a burn barrel at that site, at your hog building, Iowa law does not only allows you to burn household waste. Okay? So if you have a burn barrel there and there's no house there, you're going to have a hard time explaining how that's burning household waste. And even if you do have a house there, somebody's going to look in to see, oh, okay, what's that Thailand bottle laying in there, or whatever you're using nowadays. I'm showing, back in my days it was Thailand. Anyway, that didn't come from the house. So please, if you have a burn barrel around your livestock buildings, I'd encourage you to get rid of it, because it's just one of those things. I used to milk cows. I was, and I had a dairy inspector who came, very good people, but there were always those hot button issues that they could always find, you know. So these are one of those that it's just something that they'll look for. It's kind of on their list. And it's just kind of a red flag when you've got a burn barrel there. All right. Environmental self-audits, slide 65. We've covered those in past years. Always take a look at if you have an issue. You can submit a notice. I've jumped ahead. You can submit a notice to DNR. You have to do the paperwork correctly, but you can save yourself from money on a penalty if you discover at first that you have a violation. Nuisance cases, slide 66. Some years I'd spend maybe most of my time talking about nuisance cases. Fortunately for Iowa livestock producers, we don't have much going on here. No cases went to trial in 2009. None went to trial in 2010. And we have 4 currently pending in Iowa right now. There's a swine operation in Story County, one in Tama, and one in Marshall County. I give you the sizes there. And then a dairy in Woodbury County. Now, there's no place I can go to on the internet to look these up. I get them off the internet. It's the court's online site, but I kind of have to know about them first so I can look. There's not a general search term I can use, so there could be some here that I'm not aware of. I know there is a co-op that is being sued for nuisance for a grain site in north central Iowa for dust and noise, etc., from the grain site in town. But these are the ag nuisance cases I'm aware of. Fortunately for Iowa, this list is short. If you want a longer list, go to the state of Missouri. There is a bunch going on in Missouri right now for nuisance cases. Some of you heard about the case out of Kansas City. A Kansas City jury last spring awarded multi-million-dollar damage award in a case against Premium Standard Farms. Slide 67, nuisance steps to help avoid these. I'm not skipping over it because it's not important. Again, very important issues here. Take a look at implementing. Some of these don't work for all operations. Some aren't necessary, but always take a look at them. Okay, slide 68. In here, slide 68, insurance. Always take a look at your operation, and if you have concerns about a potential nuisance liability, take a look at your policy to see if you're covered. If not, there are policies out there that will cover you, and I make the statement standard farm liability policies don't normally cover. There are farm policies that do have it, but generally you'd have to look and make sure that coverage is there. Okay? I'm not going to cover this. I've went way over my time. We had an article in the Iowa Pork Producer Magazine about EPA on-farm oil spill prevention plans. This is not livestock related. I have the slides there. This is for all farmers. More EPA regulation here. Gene, I don't imagine you work with these at all. I'll be glad to visit with you about any of you that have questions about this. I think there's a deadline coming up in November of 2011. We'll have more in the Pork Producer Magazine about this. Just want to get this information out to you.